we'll discuss another most important concept in Islamic law, that is Waqfs, and the very definition and meaning of Waqfs as it was given by Abu Hanif. According to him, the tying of the substance of a property in the ownership of the Wakif and its returns was spent for charitable and pious purposes is called Waqf. Further, he said that it was revocable by the Wakif and he was free to dispose it of according to his will. And as Imam Muhammad defined Waqf, according to him, the right of the Waqif remained intact until he appointed a mutwali. But to Abu Yusuf, another authority on traditional Islamic law, the property right of the Waqif was extinguished and transferred to Almighty God, and the profits may be applied to the benefit of His creatures. This view is the accepted view of the Hanafi school in modern India. So the essential elements of a work are the ownership of the Waqif is extinguished, and the second essential element, the property is vested in God, and the third essential element is the profits is used for the benefit of the mankind. And according to the Shias, they define it as tying off or immobilization of the karpas, the subject matter of the work, and the profits to be utilized for the benefit of the mankind. It is not clearly mentioned as to in whom does the property vested. So scholars differ on this point. As Tayabji said, it belongs to the beneficiaries, and the very work validating act of 1913 defines a work as a permanent dedication by a person of Muslim faith of any property recognized by Muslim law for religious, pious, or charitable purposes. And now we'll go to the very origin and development of Waqf. And regarding that, Waqf did not exist in the pre-Islamic Arabia. It originated with Prophet Muhammad's utterance of the following words: tie up the substance and give away the fruits. And this is said to Omar, Ibn-al, Khattab, and who get large tracts of land in Khyber Pass. Accordingly, Omar created the first works and laid down that the property would not be sold or given away in gift or inherited. He directed that out of the income of the property Charity should be given to the needy and the relatives. The slaves should be set free. Provisions should be made for travelers and guests. Be entertained out of the profits of those lands. No systematic rules were there regarding creation of works during the early phase of Islam. So, works suffered from great uncertainty and confusion. Gradually, a body of rules governing works developed through ijma, which is the consensus opinion of the learned, and all types of property, movable and immovable, were made subject matter of works. It was laid down that works under Muslim law should be utilized for religious, pious, or charitable purposes. Further, it can be used for the benefit of oneself, one's children, and the descendants. And now we'll discuss the very objects of work. A work may be made for the rich and poor, for the rich and thereafter for the poor, and for the poor alone. And Section 2 of the Wakf Validating Act 1913 expressed that the objects must be religious, pious, or charitable, but family works are outside the very purview of the act. Yet they will take as per Hidayah, which expressly provided the very objects to be named in a work, yet they will take on the failure of the object. But according to Mullah, in his Principles of Mohammedan Law, described that following objects of a work, and they are mosques and provisions for imams to conduct worship there, and the second one, schools, colleges, universities, and provisions to teach there, and the third object would be priests, serins, and caravans, and the fourth object, according to Mullah, financial assistance to the poor for going on pilgrimage, and the fifth object should be distribution of alms to the poor, and the sixth object should be payment of money to faqirs, and the seventh object should be construction of free boundary houses for pilgrims to Mecca, and the eighth object should be for making and keeping of tajiyas, and the ninth object should be grant to an idgah or dargah or to pir, and the tenth or last object must be celebrating the death anniversary of the Wakf or members of his family, and as according to Amir Ali, an offering or gift made with the object of obtaining blessings of the Almighty would be the very object of a work, and according to Fajr, object may be made either for school hospital or a mosque, but all scholars agree that the very object of a work is the benefit of the poor, and the very English doctrine of Cypress, which means as near as possible, is applicable to works formed under Mohammedan law. If the Wakif expressed his intention that the works shall be utilized for charitable purposes and the same failed, then the income will be applied for the benefit of the poor or to the objects as near as possible to the object that had failed. So these are the objects of a work as provided under Work Validating Act 1930 and as per the Hidayah, which is another source of Islamic law, and as provided by Professor Mullah in his Principles of Mohammedan Law, so also Amir Ali and Faji. And in our upcoming video, we would like to discuss regarding the capacity to make a work. So, the very Muslim who has the capacity to make a work under Islamic law.